You have the right to remain silent. Everyone knows the words. They are read in every arrest in America, in 1,000 films, in the back of 1,000 squad cars. Say them out loud, and you can probably finish the sentence yourself. The man they are named after heard them too, on the last night of his life, on the floor of a bar in Phoenix, while a police officer stood over the man who had just put a knife in him and read that man these exact words. The man who heard them stayed silent and walked free, and Ernesto Miranda, whose name is spoken at every arrest in this country, went to his grave with no one ever convicted of his murder. This is the story of a confession that built a constitutional right, the criminal that right was named after, and a question the law has never quite closed. Was justice served? Here is what happened. In early March of 1963, an 18-year-old woman was abducted at knife point in Phoenix, driven into the desert, and raped. She survived. 10 days later, her family helped police trace a car connected to the crime. It led to a Packard, registered to a woman named Twyla Hoffman. Hoffman's common-law husband was a 22-year-old with a long record, and a familiar face at the local station. His name was Ernesto Miranda. On the morning of March 13th, detectives arrested him at home and took him to police headquarters. They put him in a lineup. The victim could not make a firm identification, but the detectives told Miranda that she had. And so, believing the case against him was already closed, he began to talk. For about 2 hours, in a small room with no lawyer present, Ernesto Miranda confessed. Out loud first, and then in a typed statement he signed his name to. At the top of that statement was a single printed paragraph, put there by the police, that would become the most important sentence in the case. It certified that he was speaking, and I quote the form, with full knowledge of my legal rights, understanding any statement I make may be used against me. There was only one problem with that sentence. It was not true. No one had told Ernesto Miranda he had the right to remain silent. No one had told him he could have a lawyer. The words were pre-printed on the page. He had simply signed underneath them. At trial that June, his court-appointed lawyer, a 73-year-old named Alvin Moore, objected to the confession. The judge overruled him and let the jury hear it. Therefore, the jury heard a man admit, in his own words, to a terrible crime. They convicted him of kidnapping and rape, and the court sentenced him to 20 to 30 years. For most men, that is where the story ends. A confession, a conviction, a cell. But Alvin Moore had made one argument that would not die. He said the confession should never have been heard at all, because his client was never told he could refuse to give it. 2 years later, that argument reached the Supreme Court of the United States. By the time it arrived, Miranda's case had company. The court folded it together with 3 others, 4 men, 4 interrogations, 4 confessions taken by police who never mentioned a right to silence or a right to a lawyer. It was Miranda's name, alphabetically first, that went on the front of the file. On June 13, 1966, the court ruled 5 votes to 4, and Chief Justice Earl Warren wrote an opinion that changed American policing overnight. The room where a suspect is questioned, Warren wrote, is not neutral. It is built to wear resistance down. So the court laid down a rule. If the police want to use what you say against you, they must first protect your right not to say it. And then Warren listed how. In a single sentence, that 100 million people would come to know by heart. That a suspect has the right to remain silent. That anything he says can be used against him in a court of law. That he has the right to the presence of an attorney. And that, if he cannot afford an attorney, one will be appointed for him. As for the printed clause on Miranda's confession, the one that swore he already knew his rights, the court was blunt. It did not, Warren wrote, approach the knowing and intelligent waiver required to relinquish constitutional rights. The confession was thrown out. The conviction was reversed. But four justices disagreed, and they disagreed hard. They believed the court had invented a rule with no footing in the Constitution, a rule that would tie the hands of police and turn the guilty loose. Justice Byron White wrote the warning that has shadowed the decision ever since. In some unknown number of cases, he wrote, "The court's rule will return a killer, a rapist or other criminal to the streets and to the environment which produced him, to repeat his crime whenever it pleases him." And here is the part almost no one remembers. The most famous defendant in America, the man who had just won at the Supreme Court, the man whose name would now protect every suspect in the country. He did not go free. Because the court had only thrown out the confession, it had not said Ernesto Miranda was innocent. So Arizona simply tried him again in 1967, this time without a single word of the statement he had signed. And this time, the prosecution had a new witness. Twyla Hoffman, his common-law wife, by now estranged from him, took the stand. She testified that after his arrest, Miranda had admitted the whole thing to her. The confession the Constitution protected him from was the one he gave the police. The confession that convicted him was the one he gave at home. The jury found him guilty a second time and sent him back to prison for 20 to 30 years. He was paroled in 1972, and in one of the strangest footnotes in American law, Ernesto Miranda spent his last 3 years selling autographed Miranda cards on the streets of Phoenix. The printed rights that carried his name, signed by the man himself, for about $1.50 each. On the 31st of January 1976, Miranda was in a bar called La Amapola in downtown Phoenix. A fight broke out over a card game. In that fight, he was stabbed. He was 34 years old. He did not survive. 2 men were connected to his killing. The police arrested one of them, and in a moment history could not have written. They read that man his rights. The right to remain silent. The right to a lawyer. The rights Ernesto Miranda had won. The man used them. He said nothing, and he was released. The second man, the one accused of holding the knife, fled across the border into Mexico. He was charged with the murder in his absence and never seen again. No one was ever convicted of the murder of Ernesto Miranda. The man was gone. The words were everywhere. Within a decade, reading a suspect their rights was routine in every police department in the country. Congress tried to undo it, passing a law in 1968 to let confessions back in without the warnings. It took 32 years. But in the year 2000, the Supreme Court struck that law down. Writing for the court, Chief Justice William Rehnquist, who had spent his career skeptical of the ruling, explained why it could no longer be touched. Miranda, he wrote, has become embedded in routine police practice to the point where the warnings have become part of our national culture. So consider what Ernesto Miranda left behind: a confession thrown out and a conviction that stuck anyway. A right that shields the innocent, born from the case of a guilty man. And a killing of the one person whose name is a promise of due process that no court ever answered for. The law that carries his name asks whether justice was done to him. The record still is not sure.